Welcome back to Scripps News Tonight. We expect the Supreme Court to hand down a few major decisions later on this week, Thursday or Friday, but we did get one key opinion today. Moore v. Harper. The justices ruled that North Carolina's highest state court did not overstep its authority in striking down a heavily gerrymandered congressional map. Chief Justice John Roberts wrote for the majority in a 6-3 opinion. The justices declined to endorse the independent state legislature theory, which would give state lawmakers broad power, virtually unchecked, to regulate voting and election rules. Gerard Filitti is with us now, senior counsel at the Lawfare Project, and has over 15 years of experience as a litigator. Gerard, former President Obama very quickly weighed in online. He said this legal theory would, quote, upend our democracy and dismantle our system of checks and balances. Is that accurate? And what is the actual impact on voters?
That's very accurate. The argument of the independent state legislature essentially flies in the face of 200 years of jurisprudence that says that the courts are a check on the executive and the legislature. The theory is essentially that a legislature has unbridled power to pass laws about the times, places, and manners of congressional elections and the manner in which states appoint electors to the Electoral College. But the courts cannot look into that. No one can, that the legislature's power is absolute. And this theory flies in the face of what has been legal practice and legal precedent for centuries. So President Obama is quite right when he says that this would upend the system as we know it. What this means in practice is that it extends to elections, to federal elections, the right of the court or the obligation of the court to step in and decide whether something is illegal, unconstitutional, and improper.
Okay, so if the average voter's thinking, lawmakers are always fighting, they're always being sneaky, they're going to keep at it, how does this affect them? And also, what are the parameters around state lawmakers' power now?
Well, it's not so much a parameter on state lawmaker power, but it is a check. It is a legal check on their ability to do things unfettered, to make laws concerning elections that cannot be examined by the courts. So in this particular case, it had to do with gerrymandering congressional districts, into arranging borders of districts to favor one party over another. And the argument that was raised was essentially that the courts cannot look into this because the power of the legislature was absolute. Therefore, everyone had to accept the borders as drawn by the state legislature. Now, again, that flies in the face of jurisprudence that enables courts to look and say that this is discriminatory. This has a discriminatory impact. It disproportionately affects minority communities. It is not a proper exercise of the legislature to draw those lines in the manner that it did, and to either send it back to the legislature to redo or to have a proposal, a court-ordered proposal on what the borders or the boundaries of the congressional district should be. So all this really does is put a check on the power of the legislature to draw congressional districts. In this particular case, it says that the court can essentially look and examine whether these are constitutional.
Got it. Okay. And I guess fairness is at the core here, is what the court weighed in on. And I know a lot of critics had said if a state legislature has engineered it in such a way that one party has more power, and then it is unbridled power, I think, as you dubbed it, that called into question the system. So in the end, Gerard, this was 6-3, written by John Roberts, not exactly a liberal. Have the court's conservatives, at least some of them, decided we're going to rein in states' claims of power?
Well, I think that the conservatives have proven to be true to their word in the sense that they're looking strictly at the Constitution and what it provides. And the Constitution provides powers to the states, but they're not unbridled. There are checks, there are balances. And I think it's a recognition that even the court's conservative faction, if you will, is not so conservative when it comes to issues that affect the entire population of the United States. They look and they employ the law as written, and they interpret it in such a manner as to benefit the rule of law and not to be usurped by legislatures. So I think this was a surprise in some extents. But on the other hand, Justice Roberts has proven to be a moderating voice on this court and not a far-right extremist as some appeared.
I see. So, I guess this is a very short answer. Was this doomed from the beginning to go to a court and say courts have no power to check us?
Honestly, it probably was. This is not the argument you want to raise, that anyone has unbridled power to do anything in the legislature. It flies in the face of jurisprudence since Marbury v. Madison at the founding fathers, which established the
That goes
power of the
back.
court. So it was quite remarkable
Right, that
that
goes
it made
back
it this
ways.
far.
Gerard Filitti with Lawfare Project. I always read you guys. Thanks so much for being here.
Thank you so much.
Coming up next, after 4 years, the Justice Department released its investigation into Jeffrey Epstein's death in federal custody. We look at the new findings in just a moment.